Hi there, I'm Clifford Bates, and welcome once again to reading Carl Schmitt's Dictatorship. We're in basically the third part. I basically divided book chapter 6, The State of Siege, into 6 parts because I want to make them smaller. I didn't want to spend an hour and a half and 2 hours on this. Even I did it too, we tried to make these little things a little more reasonable. And today, we're the third division of it, the third part, which deals with pages in the Polity, the English translation edition that's available that we're using from page 161 to 167. So continues where we left off. So we talked about this idea of the question of how state of siege emerged. This is now, he said it was a technical military issue. Now it became a political. It moved from the realm of just an aspect of a technical military aspect, question of fact, now to a question of political things, right? So it changed because of what happened with the directory taking control and deciding when the state of siege is no longer. So therefore, it continues from that point. The effect of that change was still the same as after the law of 1791. The army commander ordered what, in his view, was needed for the successful completion of a military operation. So by doing this, it still left the decision to the commander in that sense, right? Insofar as no military operation was at stake, he had towards civilians no powers that the civilian authorities were not entitled to. So therefore, no additional. In other words, if it was not a military issue, he had no additional authority. The military commander had no additional authority that he didn't have. That civilian authorities did not have. Right. For the extension of these powers, the regime of the Directorate invented a new concept, which was not as successful as that of the state of siege. Okay, new concept in that sense, right? It was nevertheless one of the most curious fabrications in the fight against the political enemy in that sense. This is what the Directory did in that time. It created a new thing. It wasn't as successful as the state of siege. Side by side with the phrase the state of siege appeared the état de trouble civil, the état de trouble civilis, the state of civil unrest. Okay, so therefore the state of siege, but now a state of civil unrest, right? When a province or canton or parish was publicly known to be in a state of upheaval, then according to the law of 27 Messidor, year 7, June 12th, July 1799, the Directorate of the Legislative Assembly could propose to declare a state of upheaval or state of civil unrest. Okay, this gave again. This is I wish the translator kept it. You're saying state of civil unrest up there, right? And you should use the same thing constantly. So, bad translator. This is one of the perks. In other words, that Assembly could declare upheaval. This permission for the measures such as the following: the relatives of immigrants and former aristocrats, the kin of robbers and chief bandits, women as well as men, were held responsible for all the occurrences of murdering and looting, and that they were held as hostages. So, for the state of upheaval, you would take a set of people, right? This is it gave permission to that relatives of immigrants, the former aristocrats, uh, the relatives of immigrants and former aristocrats, the kin of robbers, families of robbers and bandits, women as well as men, that these were held, these group of people were held responsible. They were hot for murdering and looting. And they will be held hostage, as every murder of a patriot, 4 hostages were deported. Others had penances imposed upon them, and so on. Notorious bandit chiefs, for which lists had to be compiled, were presented to special military courts and could be sentences to death without further ado. So therefore, suspected people could be given to military courts, and they special lists of their names would be then, and they'd be sentenced to death without further ado. Article 39. This law was suspended again on 22nd Brumaire, year 8, immediately after Napoleon's successful coup. The Constitution of the 22nd Brumaire 7, or 13th December 1799, and initiated instead a new development, the suspension of the Constitution. Okay? La suspension de empire of the Constitution. The scope, in other words, of the empire of the Constitution. So therefore, this idea of the suspension of the Constitution, the new idea that after this point, okay? According to Article 92, this could be declared for all regions and for as long as the armed rebellion and riots threatened the security of the state. The suspension was regulated by a law. In urgent cases, when the legislative body was not assembled, it was declared by the government, which had to convoke the legislative assembly there and then. The administrative senatus consultus, the administrative the consulting of the Senate of 16 Thermidor 10, 4th August 1802, mentions the suspension of the Constitution and the powers of the Senate, Article 55. The state of siege is not mentioned either in the Constitution of the year 8 or in the Senate Senatus Consultumus. The Senatus Consultum. Hence, the suspension of the Constitution had not yet been connected to this concept, right? This idea of state of siege. The authorization to declare a state of siege was transferred to the government on the grounds that it also had the armed forces at its disposal and could declare war. So therefore, this was to return to the state government. Okay, this is a note. Is it simply just a note? Is there something else in it to it? No, that's only the note, so let's not worry about it. There are only a few cases in which we know that the state of siege was imposed. Now, this probably will have information. Yeah, the decisions mentioned by Tennis-Fugger in the State of Siege, page 501, about the state of siege in villages of Baton on 17 Parvo 8, and Salette, Bergenacht, and Unstand concerns the suspension of the state of siege. So therefore, that's the kind of addressing of that. On the other hand, the Constitution was suspended in the Vendée region through the resolution of 7 Novice 8, year 8, and through the law of 23rd Novice 8. The army commanders sent to these areas to suppress the riots was authorized to place the rioting communities outside the Constitution, or Hoelzl the Constitution, to pass orders on pain of death, to impose extraordinary collections by way of atonement, and so on. So therefore, in other words, that the commander sent to those areas had to suppress riot. It was authorized in order to place the rioting communities outside the Constitution. In other words, they didn't have the protection. The Constitution doesn't protect them anymore. And to pass orders on pain of death, right? The government appointed exceptional courts. Napoleon had not used the state of siege as a weapon. Napoleon had not used the state of siege as a weapon in political struggles. 29, the policing function, especially the state of the surveillance that he and the extraordinary courts had at hand, were adequately measures and did not need to be discussed in detail here. And in fact, he gives an article that talks about it, right? That's, this. He says the state of surveillance, right? He doesn't have to talk about it here. Nevertheless, Napoleon had widened the context of the state of siege, and therefore justified its political expediency through the decree of 24th December 1811. From a political perspective, this was a military. From a political perspective, this was a preparatory measure for a campaign against Russia, and it had a military character. So even though it was a political move, it was it was basically a preparatory move of the Russian campaign, and therefore had its concern was military, not political. Still, when the decree was issued, it was reckoned that the upheavals of the German population in the annexed areas was possible. In other words, that it was going to cause a problem with the annexed areas of the German populations that were annexed. They might cause a problem. In other words, one had already envisioned an internal enemy. In other words, that the German population inside the annexed territories within France, now under French's control, were now seen as a possible internal enemy, right? The regulation dealt mainly with administration and services in fortified places, just as had the law of 1791, which had also given the tripartition into state of peace, state of war, and state of siege, Article 50 and forward. The state of war was declared by imperial decree when the situation required the military police to be more efficient and more effective, Article 52. The state of siege, on the other hand, was determined through a decree of the emperor or on the basis of occurrences of a siege, violent attack, raid, internal rebellion, or finally, forbidden assembly within a fortified area. The important fact about this regulation was that the formal declaration, which had to be a decree, which had a decree as its point of origin, stood side by side with real state of affairs, like the siege or the attack. So he's saying, what Schmitt is saying is that what this act does, what occurs here, is that the formal decree is put side on side. In other words, a formal decree that issued to do this, state this, is also put side by side with real conditions, like the actuality of a siege and the actuality of an attack. According to Article 92, the effect of declaring a state of war was that national and local militia groups were placed under the authority of the army chief, governor, or commander, and that civilian authorities could not issue directives without consulting the army chief. And finally, that they had to issue all the police regulations that he considered necessary for the safety of the palace or for the public peace of mind. In other words, that the police had to that they had to issue all the regulations that he considered necessary for the safety of the palace or for public peace of mind. But with this came far-reaching powers, which the army chief could exercise on the spot: compulsion to do fortifications, fortification work, expulsion of foreigners, suspects or non-productive members, expelling suspects and non-productive members, and of last resort, a general authorization to take any step that might be required for the defense and to eliminate anything that obstructed the movement of troops and the defenses. So therefore, complete authority in that sense to do all these things. Here, the ruling idea was that the benefit of the military operation justified any infringement on civil liberties, even in the absence of the suspension of constitutional provisions. The state of siege, Article 101 and Article 102, had the effect that the chief of the army became the head of civilian bodies that had anything to do with the maintenance of public order and of the police. So repeat, the state of siege had the effect that the head of the chief of the army became the head of all the civilian bodies that had anything to do with the maintenance of public order and the police. Furthermore, he retained for himself the entire authority that belonged to these bodies. So he, the political chief, in other words, he had authority over them, and he retained the authority of those bodies to him, that belonged to these bodies. He could either exercise this authority himself or delegate it at his discretion to a civilian body, which then exercised it in the name of the army chief and under his supervision throughout the entire circuit of the fortification or the blockade, in that sense. And it's that whole in the jurisdiction. There was in this jurisdiction of the authority of what he's had. It was assumed that the army chief had a general right, which did not derive from a transition of civilian function, and hence it was not a mere accumulation of the responsibilities of civilian bodies in charge of. In other words, it wasn't taking over the responsibility; it was accumulation of the responsibilities of the civilian bodies in charge of keeping the public order and security. In general, the army leader had to regulate all the affairs, both in military and civilian life, without paying heed to anything except his secret instructions. In other words, the movement of the enemy. In other words, his instructions, his orders that he's been given that he has to obey. His instructions, the movement of the enemy and the activity of the besiegers. So that in that sense. Again, 30, let's look at 30. Again, that's the title of the thing. In the state of siege, the governor or commander establishes the service of troops of the National Guard and of the civilian and military authorities, following no other rule than from his secret instructions, movements of the enemies, and efforts of procedure. That's just basically a statement of the thing. He became a commissarial chief for all public authorities. So he, at this moment in the state of siege, that the military commander became the chief commissary for all public authorities. In turn, their responsibilities and activities were only an instrument of his actions, which was governed by military objectives and therefore reached far beyond civilian functions. The transition of executive power was not the basis for the right. So it wasn't a transition of executive power for this right. It was this right that granted the military leader complete entitlement. It was just an administrative technical means of placing the bureaucratic apparatus in his hands. So therefore, it was a mechanism that gave those apparatus in his control. In that sense. Therefore, he also received functions related to the administration of justice. For all the offices that he would not entrust to ordinary courts, he used the police jurisdiction, the military police or crimes court. That is a department that dealt with all the matters involving criminal prosecutions, including those under the jurisdiction of existing magistrate. And he did so through a provost military provost, a provost marshal. He also appointed military courts in place of them. Ordinary ones, Article 103. It was not conceivable at the time that a suspension of the Constitution could be declared on account of the state of siege. Although Article 92 of the year 8's Constitution contained a provision for such a suspension, military jurisdiction, like the other functions that had to be transferred to the military authority, was a way of protecting the military objective and therefore part and parcel with the activity of the military chief. The suspension of the Constitution, according to Article 2, meant that for unconstitutional situations an unconstitutional situation could come into effect for a certain region. Through this, the Commissar of Action was able to take all necessary steps to achieve his goal. So this is in other words, there's a difference that this state of siege was really looking at it from the point of view of military objectives. Here, this is what the political objectives. In other words, a unconstitutional situation could come into effect for that region, and the Commissar's action was able to take all necessary steps to achieve his action. Thus, suspension created a space a space for action, thus eliminating legal considerations whose observance would be in a in concreto. That means in real life, would be in real life a great obstacle. But while a hostis declaration, an enemy declaration of enemy, outlawing, putting someone's above outside the law, hors de law, or treating someone as a felon, a traitor, led to the suspension of legal state only for the object of the execution, whose these territorial provisions affected both the guilty and the innocent. So therefore, this is outside this realm of this. Once the Constitution is suspended in that sense, right? And therefore, in other words, but while a enemy declaration outlawing, putting someone outside the law, or treating someone as a felon led to suspension of legal state only for the things. These territory provisions affected both the guilty and everyone would be. In other words, these other provisions only affected those who are accused, those who are the object of this, what is to be done. The suspension of this, everyone, both the guilty and the innocent. One could proceed ruthlessly, just as under the declaration of martial law. This was the meaning of the suspension of the Constitution, according to Article 92. Became evident through the orders that were given at the same time. Until the Constitution was suspended in some districts, according to the law of 23 Novice 8, 13 January 1800, above mentioned, a resolution was issued on 7th Novice 8, just 28 December 1799, that promised amnesty to the rebellious army. But it also stipulated that the leaders of the government troops could put the communities that were still in rebellion outside the Constitution, or the Constitution, outside the Constitution, with the effect that they were treated like enemies of the French people. This form of collective responsibility contained a legal complication that was absent from the hostis declaration, directed at individuals. In other words, this was collective responsibility. The hos de la Constitution, or the being outside the Constitution, was different than being declared an enemy. This is limited in that sense. It was broad and could be collective responsibility. When the chief of the army was authorized by the law of 23 Novice 8 to threaten people with the death penalty and to demand arbitrary compensations, when military tribunals were set up around the same time, it transpired that the rebellious region was treated as a war zone, although it did not cease to be a homeland and its inhabitants did not cease to be citizens. In other words, the rebellious place was basically treated like it was a war, even though it was in our country. It was in the same country, and the people they were fighting against were citizens. Okay? The idea that a certain region was outside the Constitution, Article 55, Senatus Consultum of 16 Thermidor 10, the Senate. I read the translation. When circumstances required it, the Senate declares districts to be outside the Constitution and thereby could be treated like a war zone, was used as a legal basis for the commissarial dictatorship exercised by the military commander. So in other words, that in that situation, the military commander, that once in that era, the military commander became kind of a commissarial dictator in that moment, in this condition, in that sense. Okay, pardon. Toilet paper, sorry. Yeah. COVID, right? Um, so now, although the state of siege intrusions into the civilian private sphere were likewise permissible out of military circumstances, suspension was not necessarily required as long as the idea that the state of siege is directed against the external enemy prevailed. In other words, although the state of siege intrusions into the civilian sphere was likewise permissible out of military considerations, right? Suspension was not necessarily required as long as the idea that the state of siege is directed against an external enemy prevailed in that sense. In other words, this is why the decree of 1811 must have appeared to be unconstitutional as soon as it was applied to the fight against the political enemies within. In other words, this idea of what he's saying here, the state of siege provisions, it when it was directed at enemies within, it looked wrong. Okay, it didn't have that moment, so that's why it had to be there. The state of siege was only mentioned in the Constitution of 1815, according to Article 66 of the Supplemental Act of 22 April 1815. The right to declare states of siege in cases of domestic troubles was reserved to a law under the title Citizens' Rights, the right to citizens. The reasons for these provisions lay in Napoleon's practice of government, whose unconstitutionalities were listed in the decrees of dismissal of the Senate conservator, the conservative Senate of 3 April 1814, which declared Napoleon's forfeiture of his throne. The violation of judicial independence is explicitly mentioned in the Act of Forfeiture, and so are the Emperor's unconstitutional declaration of war against Article 50 in the Constitution of Year 8, on which Merlin comments on 1807, the repertoires, that these these dispositions no longer remain in force because they are suspended implicitly by the Senate Consultum of Year 10, Article 58, and the Filial Year 12, Article 27. It was imputed that the emperor that he had mixed up the powers, postponed the People's Assembly, or without a recall, and so on. Theodore Rouge states that the decree of 24 December 1811 offered grounds of dismissal, although it was not mentioned in the official text of the act of dismissal. But one, returning to the main text, but one could not say that the emperor had made any special use of the state of siege as a political weapon in domestic struggles. Still, after the experience of the invasion of 1814, a constitution had to clarify this matter, first of all, as it was attempted in the Act Additional 1815. In civil riot, the state of siege could be declared only by legal means, that is, with corporations of the people's representatives. The decision on using military power in a military action against one's own citizen was not to be left to the emperors. In other words, the highest military commander's discretion. So in other words, it wasn't going to be the military commander's discretion after the supplementary act that this is going to be addition, that it had to be other words, had to be done through legal means in cooperation with the people's representatives. That this was not going to be mere discretion of this. But the suspension of the Constitution, as was defined by the Constitution of the Year 8 and the Senate Consultum of Year 10, which was still valid, was not mentioned in the connection with the state of siege. Although precisely the violation of constitutionally guaranteed rights, And here, the military tribunals would come to mind, was the strongest accusation against the 1811 provisions concerning the state of siege. However, as in the case of martial law, it was accepted that if the requirements of military intervention were defined in law, nobody was responsible, right? Defined in law, nobody was responsible for what happened as a result of it. Only military tribunals were seen as unconstitutional. So therefore, not that the state of siege and what was done that was unconstitutional, but only that these tribunals that were doing these things, military tribunals, were unconstitutional. And this was not just because the Constitution guaranteed every citizen a natural judge, but especially because in the military courts, the chief of the army appeared not as a soldier, but as a commissarial judge. So therefore that's the reason it was a politically legal problem. In other words, because it was the chief army does not appear as a soldier, but was the commissioned judge. The contradiction between law and mandate, or in this context, military order, between the proper responsibilities of the civilian and the military body. This was the really contentious issue of Napoleonic constitutions. After Napoleon's defeat at Waterloo, the Chambers of Representatives ruled independently, and on 28 June 1815, it appointed a military commission that was authorized to place suspicious persons, disseminators of rebellious literature and the like, under observation and to arrest them without taking them to court within the legally prescribed periods of time that fell well outside any statutory regulation, all for the sake of the public peace, right? An exceptional court of appeal was created in the chamber. In a same bill of the same day, the chamber ruled that Paris was under siege, which corresponded to the military situation. In 32, this is the state of siege. Article 52 BIS of the draft constitution of 29 July 1815 states that by law only the capital can be declared to be under siege. Hence, in a hostile invasion, the People's Assembly should have a say. The same bill ordered that civilian bodies remain functioning and that the government commission alone could take exceptional measures to protect personhoods and property. So therefore, the same bill that did this, right, did what else? It ordered that civilian bodies remain functioning and that the government commission alone could take exceptional measures to protect personhood and property. Hence, military authorities had to remain strictly limited to military operations, understood in a narrow sense. Creating a specific legal right for the exceptional authority of the government commission through the formal suspension of the Constitution had not been envisioned. With its numerous laws, the infringement of personal liberties, the freedom of the press, the Restoration government met with fervent resistance, and from the chambers of peers and deputies, and from the population alike. So therefore, there was the Restoration government. It wasn't. When it tried to do things, it was resisted. Now he says here, see my essay, Dictatorship. Sees his essay in that. He says, right. For these people, the state of siege was an administrative and technical device akin to the state of exception. Thereby, each body could do what turned out to be necessary in the specific situation. So let's repeat that. That's worth repeating. For these people, the state of siege was an administrative and technical device akin to the state of exception, whereby each body could do what turned out to be necessary in a specific situation. This is how it was used in the fight against enemies within, right? This is here is a typical formula, one that declared the state of siege in Grenoble in May 1816, though a telegraph order from the cabinet of ministers to the military leader, right? It says basically the district of Isir must be treated as being under siege. The civilian and military authorities have discretionary powers, right? That's the instruction and the order, right, to them. 34. The equality between civilian and military positions could suggest that no transition of executive power had occurred. In other words, again, no transition. But the actual course of events showed the opposite. So therefore, the equality of these things. But then what happened was that it was assisted to the civilian authorities. And he quotes the two texts. He says, the state of siege was not mentioned at all in Le Montor. And the uprising in Grenoble was only mentioned on 10 May 1816 when peace had been restored and the military occupation of highways only had now the purpose of securing the exemplary punishment for the guilty. One can get a good idea how unclear the legal situation was during the Restoration from the fact that in 1789 it was still up for discussion whether the martial law was in practice or not. Its validity was confirmed by the Chamber of Deputies in June 1820. Suggests that it would be wise to reintroduce it. It suggested that it would be wise to reintroduce it if it did not exist any longer. So yeah, in other words, they needed to exist, return to it. For these people, the state of siege was an administrative and technical. Okay, this is did that already. Hold on. This is where we just put back here. Okay. So again, the title is that the instructions, he gives the example of Grenoble, right? But now this was linked to the fight for constitutional guarantees. Now, before it was just military orders, but now this was linked to the fight for constitutional guarantees, in particular for personal freedoms and for freedom of the press. So let's stop here. I think this is where a good place to stop. This is where I plan to stop in my original listing of things for this part. If you have any questions or issues or things you want more clarification on, or explain more, or need something, please put it there. Put the questions in, and when I see them, I'll respond. If you've liked it, please like it. Hit the like button. Share it with friends. Share it on social media. If you didn't like it, you can always say down, but explain why. It would be useful. Maybe we can learn. We can do something better. The things, if you're not subscribed, please subscribe. Encourage others to subscribe and grow the channel a little bit. Bring their attention to other people. If not Schmitt and other things I've covered in that things and that. What else? It's going to be. Oh, yes. You can follow me below on social media, links below. You want to follow my academic social media stuff, it's also below the social media things, my information about my academic work and stuff like that. Next thing you can do is you want to fiscally help out what I do. You can subscribe, Patreon, listed below, links, or buy one of the books. Next time we'll continue the second, I think fourth part of the 5 parts. Book 6, chapter 6, chapter 6 on State of Siege. And I hope everything is okay. I'm still so, not feeling good, but I promise to get this done and we'll do it. Take care. Bye-bye.